Good evening. This is Laws 11057. It's week number 3. We're dealing with the new lawyer, chapter number 5, and the topic for tonight is the sources of law in Australia. Before we do, I would like to run through a couple of preliminary points. The first assignment is due just around the corner. Many people have already submitted their assignment. For those of you who have, thank you very much. The submission ideally would be in Word rather than PDF, but I will accept both. Submit your assignment on time if you haven't already done so. If you're late, you will be deducted 5% for every day that it's late, and that's according to university policy. I won't accept any applications for extension of time after the due date, so please note that. I do want to get results back as soon as possible, so please try and provide your information and your assessment as soon as you can. If you do wish to apply for an extension, make sure that you support it by, for example, medical certificates. I'm generally pretty easygoing in terms of the course, but I guess I have a reputation of being pretty tough on assignment extensions. So if you refused an extension, please don't take it personally and don't be discouraged. We want you to continue in the course. We want you to do well in the course, but I'm pretty strict in that regard. Maybe that's part of the training as being a lawyer. Judges don't like applications for extension of time. Magistrates expect you to be ready on the due date. Make sure that you don't exceed the nominated word count. If you do, there's got to be some good reason for it. Be aware, of course, that I have the Turn-It-In program, which makes it very easy to detect plagiarism. So don't be tempted. And of course, the assessment piece that you've got first up is a great assessment piece because it gives you an opportunity to know and understand and interpret a case. And the case is very apposite, of course, for those of you that are studying law. All right. Now, preferred presentation.
John, can I just...
Yes, Erin?
Can I just interrupt, John?
Yes,
you seem to be breaking up quite a bit tonight.
Oh, am I? All right. I'm not sure why that is the case.
I don't know if it's my end or yours.
All right. Now, there are a lot of chat comments. Yeah, it's breaking up a lot.
Mm-hmm.
Okay. Let me see. Was it breaking up earlier the whole time?
It was in and out, John. You were breaking up every now and then, yeah.
All right. Let me just have a look at the audio settings. Sorry to interrupt. Testing the microphone. It's coming through fairly clearly on my end. I wonder if I move things around a bit. Is it still breaking up on me?
No, that seems to be good, John.
Is that a little better? All right. Thanks for interrupting me.
No, it's getting a bit of twang to it.
Okay. Unfortunately, there's nothing obvious.
I think, John, it's saying that your network bandwidth's low.
Ah, I see. And that's what I noticed on other occasions. It might just be an internet problem in this area. I'm not sure. Does anyone know how I can somehow magically push a button and get my bandwidth to improve? Because I don't think I can. Any tech people there?
Yes, Peter can.
Who's that? Peter can?
Yes.
Yeah, sorry I can't help with that one. There's no magic fix.
Right. Thank you.
Other than turn it off and on again, which isn't going to really help us.
Okay. Well, I could start again if you want. Do you think it's worth a go, Peter?
You could try just doing audio and not video as well.
All right. I might just try that. Who was that? Was that
Most
Kurt?
definitely.
Or was that John?
Yeah, it's Kurt. If you send just audio, you'll have a better chance of it going through.
Okay. Thank you. Let me just see if I'm clever enough to do that. Now, of course, it may mean that the transmission stops, in which case I'll start again.
You should just be able to press the little stop camera logo next
Yeah.
to the audio button.
Thanks, Peter.
That-
All right.
that'll stop the video.
I'll do that now and we'll see how we go. All right. Can you hear me?
Yes.
Yes.
All
Yes.
right. And hopefully that'll be a little clearer. And of course, you don't need to see me anyway. So I'll just continue on in terms of talking about the assessment piece. And please stop me, and thanks for doing so, Erin, before. So submit your document in Word, not PDF. Use Calabri or Arial. 11 font is a good idea. 1.5 line spacing is always a good idea. If you're going to reference, and I do encourage you to do so, use footnotes. Now, does anyone not know how to use footnotes? It's really simple. You just use it straight out of the Word program. And I'm looking for anyone shaking their head. So you just go to Reference Footnotes. And a cover sheet is not necessary. You can add a cover sheet if you want. I would recommend that you look at my sample document. I suspect that I'm talking to the converted here, and I would be very surprised if there's anyone here who hasn't had a look at that document. Now, there's no great magic in my sample document, but it's given to you as a guide as to the type of layout that I think works pretty well, but it's also got some interesting content. Well, at least I think it's interesting. And so it's not just a document to look at in terms of getting a visual idea. I would like you to actually read it and read it carefully. So it gives you an idea of the way I prepare a document. I use titles and subtitles. Many people prefer headings. That's a personal preference. In that sample document, you'll see how I've used referencing, and you'll notice that when I do reference, I do tab away from the number at the bottom of the at the page where the referencing occurs. And you'll see that the size of the font is lower. It's 10 font, 10-point font, rather than 11 when we're talking about what's in the reference. So you'll see a few subtle changes there. Follow that format and that look. Now, don't use Roman numerals. Look at referencing footnotes. Take some care in how you reference a case. Don't give me the link to the internet. Just give me the legal citation, not the reference to the link. Likewise, when you're talking about legislation, give me the name of the case, the name of the statute and the year that it's enacted. Don't give me the link to www.legislation.qld.gov.au or the counterpart in Australia. I'm after the name of the Act and the year that the Act was passed. Make sure that when you're typing an Act or a case that you do so in italics, or at least the relevant part. When you're quoting from other sources, obviously you reference it, and also you indent, and in this instance I've used italics. Since I've prepared this document, I've probably gone off that a bit, and I tend not to put the quoted material in italics, but you can. What you I think you've probably noticed that I'm a member of QCAT, so I do write judgments. They're available on the court's website. You can have a look at the court's website, go to the QCAT section, put in my name, and you'll see judgments that I've written. So you'll see the way that I write judgments for the courts, for the web, and that'll give you an idea of what I do as well. Make sure that each page is paginated. Now, paginate just means put in the page number. There's nothing more fancy than that. All right. And let's see, headers and footers, should put those in, then the contents of the paper, etc. All right. So I'm sorry to give you that quick overview of the sample document, but I'd ask you to read that carefully and have a look at some of the commentary in relation to the way that Lord Denning writes. Just short, sharp sentences. You've got to be careful to avoid the temptation to ramble which is, of course, exactly what I'm doing now. So are there any questions in relation to the way that I'd like the work presented and the concept of referencing? I'm looking at the chat facility. There doesn't appear to be any questions.
Can I just ask, John?
Yes, Erin.
When you do get around to marking, how do we get feedback on that? Is it something that's sent into our inbox at the email, or what? What's the process?
What you do is you upload your assignment online, and I will then respond online. So you'll get your mark and the feedback via the way in which you upload, if that makes sense. So it will come to you. I think it'll just appear in your inbox when I'm working my way through it. Now, does anyone have any questions about how you actually upload an assignment? You've all had a look at that? All right. Now, my sound is starting to go again by the look of it. Sorry. I'll slow down the speech and speak fairly clearly, and hopefully that will help. All right. Let's get on to dealing with the sources of law in Australia. One thing that does amuse me, in the commentary, it says something to the effect, as law students, you're not expected to know all the law, but you're expected to know how to reference the law and research the law. Well, here's the news. High Court judges are not expected to know all the law. Nobody is. It's just not possible. What you are expected to do at any level is be able to research the law and provide an answer to a particular legal problem. The great thing, as I mentioned in the first week, is that there is not necessarily going to be a right or wrong answer. Coming back to the way in which High Court judges do their work, it is apparent and very common for the court to be split and some judges to disagree with others. So, as we say, it's a matter of trying to interpret and then put your own thoughts into the legal question which is before you. Having said that, there are some rules, of course. Legislation does override case law. So we have that circular situation from time to time where legislation is passed, cases come out, they interpret the law in a certain way. Parliament doesn't like the way that the courts interpreted it, so they introduce new laws to effectively overturn the case law that was created. So legislation overrides case law. Not every situation can be decided purely by reference to legislation. Is anyone able to offer some reason as to why we just don't worry about case law, we make it simple, and we just have legislation? One place to look for the law. Why don't we do that? No answers yet?
Equity?
Sorry.
Equity, yes. But why not incorporate equity into case law? Into legislation? Why do we need to bother about worrying about whether legislation overrides case law or not? We'll just have legislation.
Hopefully no one else is going to tell me off. Because it takes a long time for legislation to get passed, whereas case law is reactive to the case in question.
Yes, I think that's an entirely appropriate answer. Thank you. There are other answers as well. Anybody else wish to offer a suggestion? All right. Well, what if I was to say that not every legal situation or legal dispute can be decided purely by reference to legislation? And the reason is that legislation would be enormously detailed. We already have some huge pieces of legislation like the Commonwealth Income Tax Assessment Act, etc. Let's take an example. The law says it's an offence to drive without due care and attention. And if you're guilty of driving without due care and attention, then you commit an offence and you're liable to be fined. Why don't we just say this is what due care and attention is, so we don't have to worry about cases or judges? A police officer can say, you've done that. This is prohibited because of this section, and therefore you must pay the fine. Why don't we just bypass the whole court system completely? Any thoughts?
Is it because there could be mitigating circumstances? But I would have thought that would come into the sentencing, wouldn't it?
Yes, that would come into the sentencing, Erin, yes. And that could have an effect in terms of the fine. So, for example, in the legislation, we may prescribe, the Parliament may prescribe a certain minimum penalty, but the mitigation factors do come into it as well. All right, so that's if someone is found guilty or pleads guilty. But why do we need the courts to determine guilt or innocence anyway?
Is it because the legislation is so large, you need to have your regulations and everything to interpret the acts?
I think that's really very appropriate response. Thanks, Vicky. It's already huge, and I suppose in simple terms, we can't cater for every single circumstance that might arise. Well, let's say, for example, this. To follow on from that example, it's an offence to drive without due care and attention. Are you committing an offence if you cause an accident because you were changing radio stations at the time and you were momentarily distracted? Is it fair to say that because you changed the radio station, you then were driving without due care and attention?
Yes, I think so.
So who amongst us have not fiddled with the radio station or changed something on their iPod or CD for those of us who are a bit older?
Oh, me, of course, John. I have never done that.
I understand. So I guess the difficulty is that if the legislation was expected to be so detailed as to say that one instance of driving without due care and attention is if you, as the driver, choose to change the radio station, we then have circumstances where someone says, well, I'm not guilty because I wasn't changing the radio station, I was checking through my playlist on my iPod, and that's not in the legislation. So I think following on what Peter said and the other comments that were made, it would just become far too cumbersome. There'd be too much detail, and the cases will allow us to cater for those individual circumstances and then the individual mitigation if there's a finding of guilt. All right, I'm just looking, nobody's raised any questions, no comments. Well, let's move on. So case law, albeit that it is subservient to legislation, does form part of the law. It is determined, this is case law, is determined by reference to the doctrine of precedent, and the good old Latin term, and these things are dying, is stare decisis. Now, does anyone want to ask any questions about this doctrine of precedent? Anyone wish to offer any comments or explain it in a way that is better than I'm attempting to do? I'm looking to see if Catherine's nodding. She's not. All right, so the doctrine of precedent essentially is that if a court has made a decision which relates to a particular factual circumstance, then courts which are bound to follow those decisions must follow the way in which the earlier court had made the decision. Now, of course, it's a hierarchy situation. Magistrates presiding in a particular case in the magistrates' court must follow courts in decisions in the Court of Appeal, but judges in the Court of Appeal don't have to follow those judges that are sitting in the Supreme Court as a single judge. So there's that hierarchy situation. Now, just to confuse you a little more, sometimes it's not as clear-cut as you'd think. For example, I hope Magistrate Tatnall doesn't mind, but our local magistrate, in front of whom I appear almost on a daily basis, is of the view that he is not bound by decisions of the district court. I respectfully and have respectfully disagreed on many occasions, but that hasn't got me so far. That hasn't gotten me very far so far. So, doctrine of precedent should be clear-cut, but it's not as clear-cut as you might expect. Any questions about that? All right, well, I'll move on.
John, can
Yes,
I
Erin?
just ask, in that instance when you're talking about the magistrate, does that leave cases open to be appealed on those grounds though?
Oh, absolutely. And I can reserve those factors for the appeal court. It's a difficult process difficult in the sense that appealing means that people have to come up with funding, and that funding through the legal aid office is very hard to get. And certainly in my neck of the woods in Harvey Bay, in the jurisdiction that I practice in, generally speaking, not a lot of funds available. One of the problems with appealing too is that if you're doing so in relation to the context of a criminal law matter where people are jailed for a period of time, or perhaps a traffic matter where they're appealing the decision to disqualify for a period of time, there is the very real and practical problem of trying to get the appeal court to hear the matter so that it serves some useful purpose. There's no point having the appeal 12 months after they've served their full 3 months imprisonment, only to find that they shouldn't have served the 3 months, it should have been 2 months. Defeats the purpose, at least as far as the client is concerned. All right, now I trust that you've all had a look at the way in which legislation comes into existence. You'd all be aware that legislation begins its life through the process of being a bill that's then considered by Parliament, progresses through a number of readings, ultimately becomes law upon royal assent. Any questions about that process? You would have all read that? All right, and you'll need to know that for the next assignment piece. So those of you that have already started your second assignment, you'll know it's about legislation.
John, I've got one question, mate.
Yes, Josh?
When does the public get to question it?
Sorry, get to question the law?
When the bill's going through Parliament and that, when does the public get to what's the word for it? Challenge it?
Yeah.
During elections.
Exactly. I think that's the right answer. Yeah, I think that's the right answer. There is no specific provision as far as I'm aware, and it's a great question, Josh, because you've got me diving for my textbook, but I'm not aware of any specific provision that allows the public to necessarily have a right to comment on the way in which the law is made. Now, that Parliament may invite comment, but they don't have to, and we have had circumstances, well, particularly in Queensland, because we have no upper house, where legislation is rushed through before there's been any form of public comment. Now, does anyone wish to contradict what I'm saying or expand on what I'm saying in terms of public involvement?
You can also, I think it's 2,000 signatures. If you send it to the federal government, they're required to pass a comment on it. You can petition them, and they're legally required to give you a statement back. But there's no real way to kind of empower them to do anything other than during elections.
Great. Thanks for that response, Kurt. And of course, that's at the federal level as opposed to the state level. So thank you.
John, what's the purpose of some of the commissions that are set up by Parliament where people can have some input through those commissions?
Oh, it provides a frame of reference for a thorough investigation in relation to matters that are regarded as being generally of great public concern. And it provides that opportunity for people to have their say, for the Commissioner to consider that as part of what will ultimately become the recommendations back to Parliament. So it's not legally binding, but it does give people their voice. So that's a great point. In relation to the commissions, at least there is that opportunity to be heard to some degree. All right, now there's no questions on chat. I'll just keep moving on. For legislation, law requires the assent of the Crown. Now the Crown is a really funny concept. If you're struggling with what we mean by the Crown, you're not alone. When we have a prosecution in the higher courts, the district or the Supreme Court, then it's not so much the police or the police officer that brings the charge, it's the Crown. And the Crown is that permanent institution, if you like, which fills a void, and successive parliaments, successive executive governments fill that role on a temporary basis. But the governments come and go. The executive comes and goes. There are different departments that come and go. The Crown is if you like, that overreaching idea or concept which encapsulates all of the executive. And the Crown is represented in Australia at a federal level by the Governor-General and at state levels by the various state governors. So the Crown is an institution in Australian law. All real estate, all land and natural resources, subject to native title, of course, as we discussed last week, derive from the Crown. Title to land and resources that have not been transferred to private ownership remain with the Crown. And in non-monarchies, the concept might be described as the state or the people. So in America, they might say, you know, the people bring this action, or the state brings this action. In Australia, in Queensland, we talk about the Crown. Now, no one's asking any questions, so I assume that you're right on top of all this. Is there any comment? Any questions? No? All right, we'll move on. The Crown is not the government. So the government is responsible for the affairs of the Crown, but it is not the government, because the governments, as I say, come and go. Sometimes you hear of legislation being expressed to bind the Crown. And what that means is that the institutions of government must comply with the legislation. So even though the general rule is that laws must apply equally to everyone, sometimes those laws don't apply to the executive branch of the government. Sometimes the law must state that the Crown is bound by that legislation. I'm going to talk a bit about delegated powers and delegated legislation. This is really interesting because this is where we have a further muddling of the lines in relation to separation of powers. You would think that the separation of powers is really easy. We just have Parliament, we have the executive, and we have the courts, and they're all separate, but that's not the case. Probably the most intermingling of the two concepts is between Parliament and the executive. Now, Parliament makes laws. We've already discussed the fact that it's very difficult for Parliament to make laws that are so detailed that we don't need case law. Sometimes Parliament deal with complexity by enabling delegated legislation to come into existence. So that's where Parliament delegates the ability to make legislative type rules, and they delegate that to the executive. Now, this is commonly done through regulations. They might be rules, they might be ordinances or bylaws as well as regulations, but they're all effectively the same thing. And they're providing the executive branch power to make laws. That power is delegated to save time in Parliament. and it might cater for changed circumstances or even unforeseen circumstances. But it does provide an opportunity for that to occur. And in the commentary, there's some really interesting comments about the way in which at times the executive branch, through delegated legislation, goes further and is enabled to override the legislation itself. And the example given there on page 160 is in relation to Section 35A of the Fair Work Act, 2009. Any questions, or we're right? Okay. So we're getting fairly close to the end of tonight's session. I'll just move through a few more things that I wanted to talk about. We have in Queensland different courts, different tribunals. There are generally monetary limits for these, and I'll just go through them. Firstly, we have QCAT. Now, that's the Queensland Civil and Administrative Tribunal, and we have essentially two branches of QCAT. The first is the minor debts section, minor civil disputes section, and that deals with cases up to $25,000. Otherwise, the monetary jurisdiction of QCAT is unlimited. So if the dispute before QCAT is not a minor civil dispute, then there is no monetary limit. For example, if you have a QCAT has jurisdiction to deal with building disputes, residential building disputes. Now that might be for a home, for example, and the dispute might be claiming $1 million in damages. QCAT has power to deal with that. All right. Next we have the Magistrates Court. The Magistrates Court does have a strict monetary limit, and that is $150,000. In the District Court, the strict monetary limit is $750,000, and then we have the Supreme Court where there's unlimited jurisdiction. So when you're thinking about which court or tribunal to bring your action, think about the monetary limits. For example, if you're acting as a solicitor and you're representing a client who wishes to claim some benefit from the estate of one of their late parents because they've been left out of the will completely, you might bring an action for testator's family provision, which is claiming essentially some benefit from the estate. If the estate is worth $5 million, you bring it in the Supreme Court. If the estate is $500,000, you bring it in the District Court. If it's less than that, you've got to be careful, because even though it might be $125,000 and you'd think, well, that has to be the Magistrates Court, as we mentioned last week, the Magistrates Court or the magistrates don't have all the jurisdictional remedies available to them as do Supreme and District Court judges. So the money figure itself does not necessarily determine what is the appropriate court or tribunal. Okay, let's see. Is anyone confused by what I've said? Do you want me to explain that any differently? We're on top of it.
Can I just ask, John?
Yes, Erin.
If you have a dispute, say you work for public health or a teacher or something, and you're subjected to a disciplinary action, and you wish to appeal that, there must be a process, some sort of order in which you go, but ultimately who can that be appealed to? The highest, I guess, tribunal or court that can be appealed to?
Yes, well, it depends. The case that was set for assignment number 1 is probably, something of an example in that regard. So in that instance, the matter went to, well, I won't say the court because that's part of the assignment. But let's say you're talking about disciplinary action for lawyers or for certain medical practitioners, etc. Ultimately, they would go to the Queensland Civil and Administrative Tribunal, so that's part of the administrative function of QCAT, but they can ultimately end up in other courts at times as well. So sometimes we see decisions of the Supreme Court where there's an appeal against decisions in the tribunal. So each piece of legislation should provide a guide as to the appropriate court or tribunal, but just be careful. Right, thank you for that, Erin. Now, I just want to talk about the difference between court process or tribunal process in different circumstances. And we have a basic distinction between what we call adversarial as opposed to inquisitorial. Anyone have an idea of what's meant by adversarial or inquisitorial? Anybody want to offer a suggestion?
Well,
Sorry.
no, yeah. So basically, my understanding is that the British systems, which you'd see in the United States and Australia, are adversarial, where you've got defence and prosecutor coming against each other to convince the judge. Whereas in kind of the French system and other continental European, you've got inquisitorial, where it's mostly the judge who asks questions to try to find out the truth.
That's a great answer. Thank you. Was that Kurt, was it?
Yeah.
Thanks, Kurt. That's great. All right. Does anyone else wish to offer any further comments in relation to that? Thank you. In QCAT, we are able to inform ourselves, generally speaking, in whatever manner we see fit, subject to the rules of natural justice, and in some ways, the process that we adopt in the QCAT jurisdiction is inquisitorial, as opposed to necessarily being adversarial. All right, now let's talk about how you address the judiciary. When you're talking about a High Court judge, Federal Court judge, Family Court judge, Federal Circuit Court judge, and Supreme Court judge, socially, how would you refer to that individual? Has anyone got any ideas?
Your Honour.
You would in court, and you probably can socially as well, but that's not what we usually do. Any other thoughts?
Judge.
Judge, yep. That's it. So if, for example, you are walking along the esplanade, walking your dog, and a judge comes the other way, then the appropriate greeting would be, hello, judge. District Court judge, socially, is also known as judge. Magistrates are generally, and so QCAT members, normally just Mr. or Mrs. Many QCAT members, magistrates will invite you to address them by their first name very readily, and sometimes you may have a district or even a Supreme Court judge invite you to do the same, but I wouldn't address that individual by their first name unless you are invited to do so first. All right. Now, if you meet with the Attorney General in a social context, what's the general greeting for the Attorney General? This is essentially if you're part of the legal profession. Does anyone have an idea?
Just Attorney General, isn't it?
Yeah, even a little bit more brief. If you're part of the legal, if you're circle, if you like, it would normally just be attorney. And I'm not sure why that is, but that's kind of the abbreviated form that we use. Okay. Any questions about that? Well, I'll move on. I just want to really briefly talk about criminal trial procedures and civil trial procedure. Firstly, criminal trial procedure, pre-arrest. If you are in your first week in a law firm and a call comes through to you from the receptionist, one of our really important clients is down at the police station, the partner who is looking after that client is not available, nobody else is here, you've got to give some advice to that person straight away. What advice would you give them? Any suggestions?
Probably just tell them not to say anything that'll get them in any more trouble.
That's really good advice, Josh. Make them aware that they have the right to remain silent, and that unless there's good reason not to do it, you would recommend that they exercise that right to silence. That's great. Anything else? What else would you do if you're on the spot and you need to talk to the client or the police in those circumstances? What else would you do?
probably just determine the facts, like what's actually happened and the extent of the damage, so to speak.
And who would you determine those facts from, Josh?
The police.
I think that's a great answer. What I can tell you is that my practice is this. If I get that phone call, I'll usually be speaking to the police officer first. I would normally ask the police officer if my client has said anything in relation to the alleged offence. I would make a note of that. So if the police officer says no, they haven't, then if later in the course of the events the police officer says, well, on the way to the watch house he made certain admissions, I can remind the police officer that he or she said to me that no statement had been made by the individual. So I try and clarify that first. The second is I try to ascertain just very briefly what the matter's about. Usually the police will offer that, but they're not going to offer a lot of detail. They won't go in and tell you what evidence they've got. They won't talk about specifically what witnesses they've got, etc. That'll be kept a little close to the chest initially by police, which is all the more reason why the advice to your client should be to exercise their right to silent unless there's good reason not to do so. The next thing that I'd ascertain from the police in that first instance, even before I've spoken to the client, is whether they have formed the intention of charging my client or not. Generally speaking, they'll be upfront and say, look, we're going to charge him or her no matter what, in which case there's even more reason to exercise your right to silence. If they do indicate that they're likely to bring charges, perhaps the next question would be, do you anticipate giving the client bail from the watch house, or is bail going to be contested? If they indicate that it's probably going to be contested, what you then seek to do is make arrangements to meet them perhaps the next morning at the magistrate's court for the bail hearing. If they intend to release your client from the watch house, you might have an opportunity to negotiate any conditions of bail. For example, the police officer might say, well, I'm intending to release the client from the watch house, but I want him to report every day. I want him to do this and that and whatever, in which case you might be able to try and negotiate that down. Don't worry too much about it, because when it comes before the magistrate will make the decision about whether there should or should not be bail and whether there should or should not be conditions. Mostly, when you appear before the magistrate, you have an opportunity to water down those conditions that were imposed by the police officer on bail, but sometimes it goes the other way. The watch house keeper might release the prisoner on bail, only to find that when he or she appears in front of the magistrate for the first time, the magistrate disagrees and places them into custody. So while you wouldn't go into that during the first telephone call with the client, you might do that later. So just in summary, you get this phone call, a very important client of the firm is in the cells. What do? Speak to the police, find out if they've said anything, have they formed the opinion that they're going to charge or not, and are they going to release them on bail, maybe go into the conditions. Tell the police officer that you intend to provide the client with the standard advice. They'll know what that means. Then you say to the client, I really don't think you should say anything. It's up to you, but you'd need to convince me that there's good reason for you to say anything. And you'd explain that at this stage, while we may know some material about what they're going to charge you with, we don't have enough detail to respond. Oh, and a great question from Peter. What if it's not such an important client? Same rules apply. Very good. All right. Any questions or comments? Once we've done that, criminal trial procedure, we have to work out which court this matter will be determined in. There's a difference between indictable and summary. Summary generally means in front of a magistrate. Indictable generally means capable of being the subject of an indictment, which is in the higher courts. The distinction has been blurred even more than it was before in 2010 with the introduction of the Moynihan reforms, where many indictable offences must now be dealt with summarily, as if they were summary offences, but they're not. All right, so indictable matters are can be dealt with on indictment. Indictment is simply it's a piece of paper, essentially, and on that piece of paper it says indictment, and it alleges that a certain person has committed a certain offence at a certain time. And that piece of paper, that indictment, is presented to the district or Supreme Court judge, and that kickstarts the process in that jurisdiction. Now, I know I've moved very quickly. This is not examinable, so you don't need to worry about the detail. But I just want to give you some snippet and start you thinking about your life as a lawyer and how you're going to deal with these sort of circumstances. All right, just very briefly, civil trial procedure, quite different. Usually it's started by either a claim and statement of claim or some sort of summons or application. These are the initiating documents. The documents are filed in a court. We've talked about choosing the appropriate court. Once they're filed, you get the original back, and the court will keep an original. You'll get 2 duplicate originals back. One of them is to be served on the other side. That is the defendant or the respondent. And if the defendant or respondent chooses not to act upon them, then after the prescribed period of time, 28 days, you can go back to the court and ask for a judgment by default because they didn't respond. All right, and the only other thing I'd mention is that often alternative dispute resolution is part of the civil law procedure. Again, this is not strictly examinable, but I just want you to start thinking about how you would initiate process in various courts or tribunals. Okay, well, I've talked long enough. You probably can see me now, and please let me know if the audio is breaking up.
John, can I ask a question? And it's about something that you spoke about quite some time ago. I'll just let it slide for a little bit. Just about the delegated legislation you were talking about. Do you mean the Act is passed by Parliament and all regulations are developed by the executives? Is that the general rule?
Yes, so the Parliament will pass the legislation, and yes, generally the regulations, the rules, the bylaws, they're created through the executive. So they won't go through Parliament. There'd just be too much work for Parliament to do. So the legislation, the Act would go through Parliament, but the executive would deal with those other issues. Now, it's a great question because you've got me thinking about it, and I do hope that I'm right on that point, Vicky. And I'm not. I'm happy to be corrected if I'm wrong. So thanks, Vicky.
John, with the delegated legislation, isn't it the regulations or bylaws or rules are developed by the delegated authority and then are then passed by the Parliament? So it's taking the burden of the development of the regulations off the hands of the Parliament.
Yes, thanks, Peter. So certainly the concept is that the executive will prepare those really detailed rules and bylaws, and they can be changed relatively easily. But where I'm starting to think about the process myself is exactly how they're passed, whether, as you say, Peter, it goes back to Parliament or not. And I'd really like to have a look at that. It's a great question, Vicky. Do you have any further comment on that, Vicky? I mean, do you know?
No, I just remember I used to work with a regulator, and to change the regulations was a lot easier than changing or amending the Act. And I do remember it. I'm pretty sure it had to go through and get passed, and the minister actually tabled the regulations, and the changes, as far as I can remember.
Yes, and here's the interesting part, and this is what has got me thinking about it, because the minister has a foot in both camps. So the minister, he or she, is a member of Parliament, is a member of Cabinet, but is also, which is Parliament, which is legislature, but that very same minister is also in charge of the executive. So the question that I'm posing to myself is, the minister in that capacity, is the minister acting in an executive or a legislative function? My thought is it's executive. And the purpose of the delegated legislation is to enable the minister through the executive to come up with all those detailed rules and regulations and bylaws, and they don't have to go back to Parliament. But that's where I stand to be corrected, just to ensure that they don't in fact go back to Parliament, because I concede that I may be wrong and I need to do some research. So I'd really be interested for any further comments. Yes, Peter?
The note I've got here from the textbook on that was that the content was created by a delegated authority, and regulations are usually required to be tabled in Parliament. Stress usually.
Usually. Thank you very much. And then the question is, what does that mean, being tabled in Parliament? Does it mean that Parliament needs to consider and then pass the regulations? And I can see what you're saying. Yeah, on page 159, the most common form regulations usually required to be tabled in Parliament. That means, in theory, the legislature retains some control over the creation of the delegated legislation. If the Parliament decides that the regulations should be disallowed, they are effectively repealed and do not become law. Great, that's a great pickup. Thank you, Peter. And a really good question. Thank you very much. That teaches me that I'm going to have to read that text far more carefully than I have. I really appreciate that. Thank you. Are there any other questions? We like tricky ones. Thank you.
I did want to ask a question, funnily enough, on a not earlier topic I missed out. You mentioned with legislation that requires the Crown, I can't remember the wording you used, but the Crown to actually also, it applies to the Crown or ties to the Crown. And you said that the executive is not always, I suppose, considered or covered by that legislation. Is that due to liability and indemnity protection, or is that something else?
Look, I think you probably hit the nail on the button there, on the head. I think a lot of it does come down to ensuring that the Crown is not overwhelmed with claims and responsibility in certain circumstances. So, yes, sometimes the executive does have this get out of jail free card. I'm thinking of the work that I did in environmental law, and hopefully I can come up with some examples of that, perhaps in that environmental law context. But I think you're right, Peter, from a public policy perspective, that is correct. Thank you.
Thanks for that, John.
No, thank you. Are there any other questions? We've had some really good questions. I appreciate it. And
John, could I just ask a question?
yes, Steve.
It's again on a different topic. With regards to the assignment, you said that font 11 was good. Will it matter if font 12 is used, not for the footnotes, but for the text for answering the question?
Not at all. Look, you can use 10, you can use 11. I just happen to have used 11 in that instance. But I think in the judgments that we write in QCAT, they're 12. So, no, that's fine. Thank you.
No worries. Just checking, because I've got it all in 12. And if I need to change it, then I'll do it. But if you're okay with 12, then I'll leave it. 12
is fine. 12 is great. Yep. That's no problems at all. Purely a recommendation, not prescribed at all. And of course, others in my situation might entirely disagree and say that it should be 12. So, no, that's great. Thanks, Steve. Thank you, Catherine. Any further questions, comments? All right. Well, we might wrap it up for tonight. I'll stop recording now. Thank you very much for joining us.